On December 30th, 2020, as Donald Trump and his allies were debating whether to install Justice Department lawyer Jeffrey Clark as Attorney General and potentially set in motion a constitutional crisis driven by fraudulent claims of voter fraud, Clark received a text from Pennsylvania Republican Congressman Scott Perry. The text read, quote, "POTUS seems very happy with your response. I read it just as you dictated." Clark replied, "I'm praying. This makes me quite nervous and wonder if I'm worthy or ready." Perry responded, "You are the man. I have confirmed it. God does what he does for a reason." The exchange comes in a court filing that was briefly unsealed yesterday by the D.C. Circuit Court of Appeals as part of an ongoing dispute over how much access special counsel Jack Smith has to Perry's cell phone. Days after these text messages were sent, Trump tried to install Clark as acting attorney general. A move, which we know from the January 6th hearings, was foiled by pushback from former acting Attorney General Jeffrey Rosen and Deputy Acting Attorney General Richard Donoghue, among others. But the new text messages reveal Congressman Scott Perry knew a lot about efforts to overturn the 2020 election, starting with Jeffrey Clark. Joining our conversation, former lead investigator for the January 6th Select Committee, Tim Heaphy, is back. Claire and Basil are here as well. Tim, your committee, you investigated how Perry introduced Clark to Trump. What do you make of these texts?
Yeah, they're direct evidence of what we found circumstantially, that Scott Perry was right in the middle of the effort to install an acting attorney general who was prepared to take action without basis in fact or law. There were some texts from Perry to Meadows, which we received from Mark Meadows, so we were aware of his involvement in this single prong of the multi-pronged plan to disrupt the transfer of power by using the Justice Department. But the direct communications that have now been unsealed, or at least put forth in this pleading, shows how directly he was involved, dictating messages to the president from Jeffrey Clark. It puts the president himself in the middle of this misguided plan and shows that Perry was the orchestrator. So I think it's very significant. And it shows that the Justice Department has tools that we didn't have. They can get Scott Perry's phone. They imaged it. They found these texts. We subpoenaed Scott Perry, and he said, "I'm not coming." So Jack Smith is using the tools at his disposal to get additional information beyond the circumstantial evidence that we found, not just about Scott Perry, but about a lot of things.
So, Tim, once you have that information, how does he then use it?
Well, he uses it to potentially get Scott Perry as a witness. He uses it to tell the story of the president's direct knowledge. Again, Jack Smith has to prove that the president specifically intended to disrupt the joint session. His use of the Justice Department and contemplation of personnel change. Jeff Clark, remember, was prepared to send a letter to state legislatures, essentially asking them to hold special sessions and put forth these alternate fake slates of electors, and publicly declare that the Justice Department had serious concerns about election integrity without factual foundation. So he's prepared, despite the chorus of people telling him that there's no basis for this, to use an arm of the federal government, the Justice Department, as one prong of that scheme. It bears directly upon the president's intent, and that's why it's important evidence for the special counsel.
And Claire, let's remember the stakes here. You have Politico reporting that the newly disclosed documents reveal an extraordinary web of communications between Perry, who is now the chair of the House Freedom Caucus, and key figures in Trump's orbit. They include a series of exchanges between Perry and a former DOJ colleague, Robert Gassaway, between December 30th, 2020 and January 5th, 2021, in which Perry embraced a plan to have then Vice President Mike Pence admit testimony prior to the counting of electoral votes on January 6th. Perry agreed to sell the idea with a call to Trump, Pence and Trump advisor John Eastman, but Perry later alerted Gassaway that Pence's chief of staff, Mark Short, will not allow access. I mean, Claire, when you consider the new ABC reporting, just how close Mike Pence was to not presiding over the joint session, this seems like a pretty frightening revelation.
It's all frightening. And, you want a scary fact? Keep in mind what stopped this step of the coup. Putting Jeffrey Clark in to do whatever the crazy clown car of lawyers told him to do. The Sidney Powells, the Giulianis, the Jenna Ellises. What stopped that were people in the White House and people in DOJ that said no. We will all resign in bulk if you do this. It will expose you as being somebody who is doing something so outside the norm and frankly criminal. So he didn't do it. But guess what would happen in his next term? He's going to surround himself with the Perrys, with the Jenna Ellises, with the Boeberts, with the Jeff Clarks. All the people around him are going to be the people who will bend to his will. He's already said that. So that's what's really scary about this, is that he is a credible candidate for president of the United States.
Well, Tim, Claire name-checked Jeffrey Clark, and so I want to talk about something else that shows up in this Washington Post piece. When Clark wanted access to extremely sensitive intelligence about the election results, he again turned to Perry, the court documents show. In a text conversation beginning on New Year's Day, Clark asked Perry to tell the president that Gina Haspel, then the head of the CIA, needs to get me the tickets, meaning Clark wanted access to highly classified, compartmented information. Senior U.S. officials often refer to their access to such closely guarded government secrets as tickets. To that request, Perry replied, Roger, and later texted Clark, POTUS is giving you a presidential security clearance. It seems like a lot of access, Tim, for the White House to give to a congressperson.
Yeah, and he got access, right? The key thing to remember is that Jeff Clark got that access to that information, which showed absolutely no evidence of foreign interference in the election. He got access to that intelligence. Nonetheless, he persisted in this scheme to send this letter to state legislatures, encouraging them to hold special sessions and to announce that there were concerns about voting fraud. Again, the facts didn't matter. When he was given the facts, the plan didn't change. It was never about the facts. It was about a political strategy. So it's shocking that a congressman and then this lower level official of the Department of Justice get access to this highly classified, sensitive information about election security. But even when he got it, despite how outrageous that was, it didn't change the plan. Yeah. Again, this whole thing was disconnected from facts. That's what makes it so troubling.
Well, Tim, let me ask you, does this have any impact then on Fulton County DA Fani Willis's case against Jeffrey Clark in Georgia?
Yeah, potentially it does. They're very similar allegations. The RICO allegation in Georgia and the special counsel's obstruction of an official proceeding case are essentially the same core fact. Clark's a charged defendant in Georgia. So here you have him, again, getting access to this information, yet persisting in these steps as part of a conspiracy to disrupt the joint session absolutely has relevance. Everything that Jack Smith develops potentially has relevance in Georgia and vice versa. When people cooperate in Georgia, that has potential impact on the special counsel's case because of how closely factually intertwined they are. I'm sure they're not explicitly cooperating, but there's nothing to prevent Jack Smith from reaching out to a cooperating defendant in Georgia, and there's nothing that prevents Fani Willis from reaching out for information that's developed in the special counsel case.